In June 2022, I reviewed virtually every property law case from the past year that reached a state Supreme Court. So if the case was decided between March 2022 up through about June 2023, in these specific areas of law, I reviewed it. So in those areas were adverse possession, boundary disputes, common interest communities, covenants and servitudes, easements, licenses, nuisances, and zoning. If you don't know what those are, don't worry about it. But during all of that review, I found one particular case that was an absolute stinker. There might be worse cases out there, but I didn't see any. I reviewed several thousand cases, and this one was genuinely nasty. And so I just wanted to give it a shout out for probably like easily being my least favorite property case out of the hundreds or thousands that I reviewed that came out in the past year. So the case, it's a series of cases called WDIS. I have no clue how to pronounce that. WDIS v. High Country States Homeowners Association. It's a case in Utah, which is fairly close to home for me. And somewhat close anyway. And it is a HOA case, so Homeowners Association issue. And the story goes this way. Back in the 70s, early 70s, a guy forms a HOA. But here's the problem. It's one guy forming a HOA. That's not how HOAs work. HOAs are formed out of contracts, basically. And they're basically negotiations between somebody who has, they're built into the contracts through which you buy a house or buy property. That's where HOAs come from. They're from the contracts. The problem here is that the guy who created this HOA back in the 70s, he owned 0.4% of the land that he was establishing a HOA for, and had no claims whatsoever to the rest of it. He owned, I believe it was about 8 acres. 8 out of 2,000 acres that he established a HOA for. You can't just establish a HOA over land you don't own and have no interest in. So essentially, I would characterize there's definitely an appearance of fraud here. One has to ask why this HOA was formed, what happened with the HOA fees after it was formed. Based on false information, things like that, and what its regulatory character was. How assertive was it? Because those are things I'm concerned about. Because it's like, why would you set up a HOA over a bunch of land you don't own, except to either derive illegitimate income from it, like steal HOA fees, or possibly to control the area's development unjustly, because HOAs have a lot of control over aesthetic developments and the like. Fast forward to this decade, and we start getting some of the people who are subject to the HOA discover these faults in the HOA's founding documents and they refuse to acknowledge the HOA's authority. And they basically sue in an action called a quiet title action. They basically seek to establish that they own the land, and the HOA does not have any interest in the land, because HOAs actually do have interests in your land. That's basically how they derive their authority, is by actually retaining an interest in the land you have through, say, a lien. And if you don't comply with HOA ordinances, they can actually seize your home like a typical HOA arrangement. And HOAs have done this HOAs have seized homes from people over very, very minor things, like very minor unpaid fees, things like that. So we get this litigation challenging the legitimacy of the HOA. And the court, long story short, the court initially decides that the contract creating the HOA is what's known as a voidable contract. A voidable contract is distinct from a void contract because a void contract if a court finds a contract as void, it's gone. It doesn't exist at all. And typically a court will void a contract if there's serious ethical issues with it. It's pretty rare, but But yeah, that's what leads to avoided contract. Avoidable contract is similar. There are ethical issues, or there are things about the contract that don't conform with public policy. But the difference between avoidable contract and a void contract is that where the court destroys the void contract, basically says this contract never existed, avoidable contract is still acceptable by the victim of whatever bad behavior happened. So in this case, a related example of avoidable contract would be like a contract with children, people who are underage. Those contracts are typically voidable because it's against public policy, and there are morality issues with setting up contracts, especially contracts with actually like binding terms with like kids. Like they don't know how to. It's like they're not fully equipped to handle oftentimes the obligations that come with contracts. And just because contracts can have very, very serious ramifications for noncompliance or for breach. But rather than getting rid of the contract when this happens, we give the child, the victim, and we let the child choose whether they want the contract or not once the court declares it voidable. So if the kid really does want to go forward on the contract, they can. The child basically gets the full choice. They can choose to void it and make the contract as if it never existed, or they can basically affirm the contract or ratify the contract is the term, and basically say, yes, we know there are problems with the contract. We're going to maybe eliminate the problem. The court might modify the contract a bit, get rid of whatever problematic provisions may be in there, and then say, like, now that we've cured the defects, the issues with the contract, you can accept it if you want to. Because, like, say, like a child buys, like one example, a historical example is like a kid buys a car. The contract's not legal. It's voidable because it was a contract with a child. But if the child wants to keep that car that they bought, then they would want to ratify the contract rather than void it. Because if they void it, then they get nothing. They'd have to give back the car, and they'd get their money back, but they'd have to also give back the car. So the court in WDIS the High Country Estates Homeowners Association decides that this homeowners association contract is voidable, which is an agreement I agree with. I think it's a pretty good way to handle it. There's very serious issues with the formation of this contract. So it makes sense to declare it voidable, and voidable is just kind of more amenable than declaring it void, because if you declare it void, it's just gone. Giving people the chance to say, I think it's often a decent choice for a court to just declare it voidable instead of void, because that lets the parties decide to kind of like renegotiate. Like it makes it easier for them to like come to terms again, if they do want to continue a relationship. And the victim is always left the choice to deny, to basically say, like they have a lot of bargaining power in this context, because they're the ones who decide whether the contract's void or not. And they can just wipe away the contract whenever they want, or like until it's ratified anyway. As long as the contract hasn't yet been ratified, the victim can get rid of it and just wipe away the consequences. So you can get you can go from a very unfair contract context to a situation where the victim has a lot of leverage and the weight of the court behind it, so that we can actually get a much better result through a voidable contract, a declaration that a contract is voidable. So up until this point, I actually agree with the court. I think the court's totally fine up to this point. What's next is the part that I think is it's wild. So the court declares that the HOA contract is voidable, but that the landowners subject to the HOA have already ratified the contract by virtue of acting as if the HOA had authority over them. And that is wild to me, because HOAs, as I already mentioned, they have coercive force. If you don't comply with a HOA, they can seize your home. They can like demand money from you, all kinds of things. And if you don't know that your HOA is invalid, which more HOAs are probably invalid than we probably realize. A lot of HOAs have very, very severe contractual defects. and some very sloppy contracts writing. But the thing is, if you don't know that the HOA is illegitimate, then it is so dangerous to not to not correspond to the demands of the HOA. So the fact that the court here decides that just because they've acted it's not like this line of reasoning isn't used elsewhere, but it's just like it doesn't fit here. It really doesn't fit here, because it's like you're not, unless you know that the HOA is legitimate, you're not going to act. You shouldn't act against it. Is the thing. And they basically, as soon as these landowners at issue, the plaintiffs here, as soon as they discovered the issue, they basically immediately began to deny the HOA's authority. So basically, as soon as they knew there was a defect in the HOA, they began to deny its authority and act as if there were no contract, which is what you'd expect from somebody who's a victim of fraud. And just the fact that like this HOA obtained power over people, real legal power, through fraud, through a lie, because people believed the lie and responded to threats of force, is terrifying to me. And it really makes me concerned about like the overall health of this HOA organization, and also just like what this HOA has been doing, because it's been exercising unjust legal control over this community, controlling like 2,000 acres of development and determining what people can build, what kinds of houses, what kinds of aesthetics. They've been issuing fines. They've been collecting assessments. They've been taking money from these property owners, and there hasn't been an oversight mechanism. There hasn't been, I mean, that's a problem with almost all HOAs, to be frank, but there hasn't been oversight. There hasn't even been a contractual agreement. There isn't even a nominal agreement to this. Because it's like in any HOA contract, the consent is kind of manufactured. A lot of the times it's like you don't really have an alternative. But here, there isn't. This HOA was never consented to, and who knows where the HOA funds have gone. And like, I don't know, that some of that is getting into some speculation that is probably like going beyond the pale, just in the sense that it's like, I just don't trust HOAs generally. So it's like, I don't trust them with money. A lot of them handle money very poorly, and it's like they don't have the necessary very few of them have the necessary oversight to make sure that they're not abusing their power or embezzling funds. But that doesn't mean they are. Just that the particular context, the fact that this whole HOA was founded on fraud makes me like very worried about like, what did the founder do while he was alive? Because it's been 50 years since the HOA was founded. So like the HOA as it stands could actually be very legitimate and like well organized, and who knows? I don't know. I'm not going to say, I don't know those details, but, when you start off on a foot like this, that's not good. Not good. But yeah, just to emphasize the point that I find really offensive is this notion of obtaining legal power over somebody because they believed a lie. It's like, imagine if, I don't know, like pirates, like if you believe, like if or a better example, like if if somebody dresses up as a police officer and threatens you or like arrests you, like somebody dresses up as a police officer and arrests you, that arrest is illegitimate. And the fact that you acted as if the person were actually a police officer doesn't make the arrest legal. Or like if you're a victim of a scam, whether it's a scam claiming to be the IRS or a debt collector or what have you, the fact that you believed the scam doesn't make the scam valid. And HOAs have so much power, because like power over your home is a terrifying thing, and it's a big reason why I oppose HOAs almost generally. It's like there's a very limited space I think HOAs make sense. But the HOA as it exists in modern law is, I think, a terrifying institution and subverts like a lot of constitutional principles and junk like that. But that's a discussion for another day. But yeah, I do not like people getting power through this way. And I don't know. It's like I don't. It may be that the fact that the court's decisions are split over several cases, so maybe they didn't see the narrative the same way I did, or maybe it's like there's always a possibility that there's legal principles or like facts that I'm not aware of that the court may have been. But even when I've had even when I've discussed with others who've read these cases, it's they've been pretty shocked as well. And it doesn't seem, at least the decision as it's written is shocking. And I don't think it represents the principles of justice or good law. And I don't think it even represents the law, because that's what a court, it's like the court sometimes has to make decisions it doesn't like and pass down decisions that it would rather not. But it's supposed to do that when when the law demands it. And I don't think the outcome here is what the law demands. I don't think the legal precedent, I don't think makes it like says that this HOA exists. I don't think it does. I'm not an expert. This is not legal advice or like, I could be wrong. But this is my read on it. And yeah, very bizarre case. And it's like of all the cases I've read, like of all the property cases I reviewed over the past year, this was easily the worst, easily. Because it's like most of the other cases, decent enough. It's like you may disagree on some nuances or things like that, but nothing like glaringly bad. Whether it's a case in Hawaii where somebody's home they were improperly expelled from their home by I believe it was a creditor. Like the court eventually fixed that. It was too late. Well, it was like much later than you'd want it to be. It's like you don't want a person to be kicked out of their house in the first place, but the court ultimately set things right and said this was wrong and things like that. There were also a lot of cases about golf courses over the past year. There was a case about COVID, about I think it was like a theme, like it wasn't quite a theme park, but it was like kind of one of those kinds of places denying it. Somebody was arguing that there had been a breach of contract because their season passed didn't work all season because of COVID cancellations, things like that. And that argument didn't fly with the court, stuff like that. The golf course cases were kind of fun too, but yeah, here's to the law and hoping we can do our best to make good law because that really matters. Adios, au revoir, and see y'all on the flip side. And sorry this took so long. It's like, hopefully you don't mind the length on this. It's a bit longer, but also it's a legal case. It takes a bit more time to explain. So au revoir.